Hey, Paul here again, and in this video we're going to discuss what's involved in the selling of a home or another piece of real estate after the homeowner or property owner dies. Okay, so it's not uncommon, blooper reel. I'm going to keep going. Not uncommon for the home or real estate of someone who died. It's not uncommon for the heirs to need to get that property sold. Now, in some cases, perhaps an heir will continue living in the home of the deceased person, but it's common for everybody want to sell that property so the funds can get divided up. So really the question today is, what's involved and how in the world do you go about selling the home of someone who passed away? Well, the answer, as in most legal and estate scenarios, is it depends. And I'm going to go through several different scenarios to give you the big picture, and you'll have a good understanding. And I'm going to go through maybe 3 different scenarios. One, kind of common, getting more popular, is when the homeowner, before he died, he or she, the homeowner, before he died, he created a living trust and he transferred the title of the home to his living trust. So let's say Dave is 70 years old. He wants to make it easy for his heirs to settle his estate. He sets up the Dave Living Trust, transfers the title of his home to Dave as trustee of the Dave Living Trust. When Dave dies, in Dave's trust, Dave had named a successor trustee of his trust. Let's call that Tom. And Dave also named beneficiaries of his living trust, who's going to get all the trust assets when Dave dies. So Dave dies. The next day, Tom plunks the for sale sign down in the yard of Dave's house. Things in a trust, you don't have to get a judge involved. You don't have to get courts involved. Things in a trust, avoid that. So as we go from kind of easiest to most difficult, that's maybe the easiest scenario, is Dave putting his home in his living trust and having the appropriate provisions in the trust where he names a successor trustee and names beneficiaries to receive the home or the proceeds of the sale of that home after Dave dies. So in that living trust, really no delay. That successor trustee can take action immediately and sell the home, and then of course that successor trustee, the proceeds from the sale of that home would be payable to the trust and would go into a trust account, perhaps at a bank or financial institution, and then that successor trustee would disperse the proceeds to the principal beneficiaries of Dave's trust. Okay, enough there. Example number 2 is the home was in Dave's name when he died, and now his executor needs to sell it. And under this scenario, where I can break down this, how a succession or how a house is sold in a probate. And again, this can vary from state to state. I live and work in Louisiana, but I know other states have what's called the independent administration provisions. So the second scenario is Dave's home is sold during his probate, or as we say in Louisiana, during his succession, and it's sold by either an independent administrator or an independent executor. So by that I mean Dave either wrote a will, named Tom as the executor, and in his will he stated that Tom may act as an independent executor, or Dave didn't have a will and all of his heirs after Dave died signed an agreement to allow the designated administrator to be an independent administrator. So when someone is an independent administrator, no will, or independent executor, named as such in the will, then that administrator or executor can take certain actions after Dave died, independent of court approval. So now, still after Dave dies, the heirs generally have to get together and get with a lawyer, and pleadings get prepared, and those have to be submitted at the courthouse to get that executor confirmed or that administrator appointed. And here today, that would be a nightmare since courthouses are quasi-closed and really seem to be only handling, criminal matters and restraining orders and those real emergencies. All the probate and estate settlement stuff, I gotta feel like is just piling up somewhere at the courthouse, not getting addressed. So nonetheless, even if there is an independent administrator or independent executor, again, check your state law, there's still going to be some delay because a judge has to get involved in confirming that the will is valid and signing the appropriate court orders to confirm the executor, appoint the administrator, and then all that paperwork has to go through the processing department at the courthouse, and that just takes some time. But once that independent executor is confirmed, then Tom, as independent executor, can sell the house. Money at the closing check would be payable to estate of Dave. Dave would deposit that into some estate of Dave account, and then ultimately, after more court stuff and more pleadings and more court orders, Dave would then disperse those funds out of the estate pursuant to the court order to the appropriate heirs. So that's how that would work. So we got number one, it's in trust, really easy. 2, independent executor, still some hoops to go through. And then the even more difficult scenario is when an estate or a succession or a house or piece of property needs to be sold as part of the probate estate settlement, and you don't have what's called an independent administrator or independent executor. This is often the case perhaps when a will doesn't authorize independent administration, or when someone doesn't have the will and all of the heirs, or at least one of the heirs, is uncooperative and won't sign the appropriate agreement allowing Tom or whoever to be an independent administrator. Or sometimes we can't get an independent administrator appointed when the succession, let's say it's maybe 10 years old, and we can't find all of the heirs quickly to sign an agreement to allow an administrator to be an independent administrator. So in some cases, it's just not practical or not feasible to have an independent administrator or independent executor. And then, quite frankly, it's a kind of a nightmare for the estate to sell a home or a piece of real estate. Here in my state, we have a provision that says, if there's going to be a petition for private sale is what this would be, then that you have to do all these, give all these notices in publications and in newspapers. Here's just reading from our procedural articles. Notice of the application for authority to sell succession property at a private sale shall be published at least once for movable property and at least twice for immovable property. Real estate is immovable property in the manner provided by law, blah, blah, blah. The notice shall be published in the parish in which the succession proceeding is pending. When immovable property is situated in another parish to be sold, the notice shall also be published in the parish in which the property is situated. Kind of sounds simple enough, but it's a nightmare. You're dealing with newspaper publications, you're dealing with courts, and you're dealing with clerk of court processing. They have to get verification that everything's been done and all the steps are made. Then you're getting judges involved in approving the sale, and oftentimes sales are lost because there's a buyer of the home. He wants to buy it, in 30 days, but you have to tell him, we're not going to get approval for 4 months. So you can't buy this house for 4 months. They go and buy another house. It's a mess. Okay, so I guess the other option is just flat out complete the probate matter. Maybe dad died, had 3 kids. They work through completing the probate, transferring the home from dad or Dave's name into the 3 children's names as co-owners. And then the 3 children would be the co-owners, and they would sell the property together. All would have to sign on the sale paperwork. Proceeds would be paid out 1/3, to each of the 3 co-owners. So that's another option, but that requires completing the probate before that sale can take place. So, good example there. We've got some examples of trust. We've got some examples of different kinds of executors and administrators, independent or not. And by the way, you do have a like button there that we want you to obliterate. You don't need any court approval to smash the like button, so go ahead and do that. Also, as a final note, I'm going to be presenting some YouTube live presentations over the next 6 days, 10 a.m. Central Time each morning, on different topics related to estate planning. It's the questions that we get all the time. You'll be able to ask your questions live in the chat and have me answer them. Go to our channels, our YouTube channels community tab for more details. Okay, we'll see you next time.